A quiet title action can save your home, and another title for this video could be In Defense of Quiet Title Actions. Quiet title actions must be good because sellers of other services are attacking quiet title actions. They're claiming falsely that a quiet title action is of no value and that you should instead buy their snake oil. My name is Carl Pearson. I'm an attorney spending most of my time in defending against foreclosures, and I'm helping clients throughout the United States. I have more than 100 YouTube videos, most of which are about foreclosures, and the one last thing I want you to know about me is that I fight the banks in court for reasons I'll make clear in this video. Here is what you need to know to make the decision for yourself about quiet title actions. You have several types of snake oil or possible snake oil being marketed to desperate homeowners, including 1. Online seminars, 2. Weekend seminars or camps, 3. Securitization audits, 4. Telephone advice by someone who does not go into court concerning a homeowner's options, 5. Assistance in preparing a loan modification application to be sent directly to the bank, and 6. Court-ordered mediation or conferencing. The one difference between quiet title and each of these 6 alternative remedies is, take a guess, lawsuit, litigation against the servicer, REMIC Trustee, or other investor. None of these competing remedies requires an attorney with litigation skills to go up against the bank, and for such reason, as I'll explain shortly, is probably not going to result in saving the homeowner's home. This is so in spite of the amount of money that may be spent acquiring the information or services. The amount of money you pay is not an indication of the value of the information or service, and instead is the amount of money you are throwing away, so that you have had even less of a possibility in saving your home from foreclosure. The cost of the bank for each of these remedies ranges between $0 and $4. The $4 cost is my estimate of the 4 hours of time spent by a variety of telephone representatives living in a barracks compound in India, paid about $1 per hour, who find repeatedly and continually fault with the applications, so that the bank tells the homeowner finally that their applications are denied or considered to be withdrawn when the homeowner finally stops submitting additional requested information. At this cost of $4, when it denies the loan modification application, the bank and its investors, that is the persons who bought beneficial interests in the pooled loans, saves on the average about $100,000 to $150,000 in interest and principal reductions over the lifetime of the loan. And because of the denial of these applications, the loan is going to become a horrible end very shortly through foreclosure and sale. So much for snake oil salesmen and saleswomen. Now, let's look at the so-called quiet title actions and see what they're about. First of all, you have to recognize that they are not anything at all like real property quiet title actions, in which a landowner names and sues everyone who might have an interest in the real estate and advertises his or her lawsuit in the newspaper selected by the court to tell the world that they had better come into court to protect their claimed interest in the real property, or lose it by reason of the forthcoming judgment in the quiet title action, real estate type. The second important point for you to know, and something which will probably be disbelieved by 90% of the people who look at this video, is that there is no free and clear. Read my lips. There is no free and clear. By that I mean that you have no legitimate expectation in getting your property free and clear by eliminating the note and mortgage or otherwise when you try to save your home through any process, whether by drinking the snake oil or by a quiet title action. Snake oil salespersons have been selling free and clear as a way of having homeowners part with their money, but there is no free and clear, except for perhaps 1 in 1,000 homeowners. Almost all of the title evils you are learning about through the salespersons are in fact curable in the long run by the bank and its attorneys, even robo-signing. And the backdating of documents is not illegal when needed to create lawful title documents. And it is not absolutely necessary for the owner of the note and mortgage to have the original copy of the note in its, her, or his possession. An affidavit explaining the inability to produce the original note is generally accepted in most, if not all, states in the U.S. So wake up and don't be fooled by snake oil salespersons. Your remedy is a quiet title action, but you need to know what that means. It is not self-evident, and it is certainly not a real estate action commonly called a quiet title action. The quiet title action which I'm talking about, which is saving homes for homeowners, is a lawsuit brought by the homeowner alleging a variety of claims having nothing to do with the real estate. There is no complete list of claims. They will vary according to the facts of the situation. The lawyer representing the homeowner, applicable decisions, and taking into account new ideas as well as past failures. It is important to note at this moment that if the homeowner's loan was not securitized at some point, there may be little or no reason to commence a quiet title action, because the claims are based for the most part, but not all, on securitization of the note and mortgage. If a local savings bank made the loan, it probably never sold the loan and has the note and mortgage in its safe deposit box and can produce it readily. A quiet title action at a minimum should allege 1. The servicer and alleged investor or owner of the note do not hold, own, or possess the note, and do not have the authority from its holder, owner, or possessor to enforce the note. 2. The homeowner has been making his or her monthly payments of, now let's assume $2,000 per month for 5 years, a total of $120,000, to the wrong entity, and the defendants are being sued to recover such payments together with simple interest of 9% per year in New York or some other percentage in other states. 3. The banks have been involved in a fraudulent loan modification program in which they pretended to review your application for a loan mod and had induced the homeowner to go into default before the bank would consider the application, but at all times knew that it was, as a practical matter, as to the vast majority of such applications, going to deny the application, and because the homeowner is now in default, at the request of the bank is now able to foreclose and sell the homeowner's home. Not only should you ask for damages and an injunction from selling the property, but you should be asking for punitive damages as well. 4. This fraudulent activity is a violation of your state law prohibiting deceptive practices against consumers, which may also have punitive damages as one of its remedies. 5. You should be seeking reformation of the note so that it is reduced in principal to the present value of the property, if your property is underwater, and to the present market rate for interest on residential loans, which may be in the neighborhood of 3.5% to 4% at this time, but changing. Now, let me ask you a question. What do you think the bank is going to spend in its defense of this type of lawsuit? What are the expected costs of discovery, including the service as well as the answering of interrogatories, the preparation and the answering of requests to admit, and requests for document production, and the preparation of notices of depositions, and attending perhaps 20 hours of depositions, with the attorney rates for the banks being in the neighborhood of about $400 per hour? If you want my guess, I think the bank is facing $50,000 to $100,000 in legal costs. But I have seen the bank's expense go to over an estimated $3 million, yes, in the course of a 5-year battle that is continuing at this moment. A $200,000 mortgage on an underwater property worth $100,000 could be wiped out by this quiet title action, and the best result for everyone, including the homeowner, the bank, the investors, and the court, and at least for me definitely, and hopefully for the bank's attorneys, is to settle the case through the grant of a suitable loan modification agreement, including a reduction in monthly interest and a reduction in principal amount to the value of the property. Remember, the investors in the pooled loans have to be queried by the REMIC Trustee as to whether they are willing to grant the interest and principal reduction. And if there is no costly litigation to be absorbed, they can be expected to vote against the loan modification proposal. But if they have to pay the $50,000 to $100,000 cost of the litigation out of their pooled investment assets, they will much more likely approve a reasonable loan modification, particularly because the reduced principal amount and market rate of interest is no more than what the banking system will get when the property is sold at auction to a third party for this reduced value, with perhaps the same bank giving the purchaser a loan at the present market rate of interest. So, a quiet title action does no more than force the bank, actually the thousands of investors in the pooled loans, to make the right decision, which is to let the homeowner remain in the home, paying an amount that he or she can afford, terminate the litigation, and bring the property back to performing far more quickly than going through the foreclosure process. One client of mine has not paid the mortgage for 9 years and another for 5 years. Granted, these are exceptional cases, but who knows today which case is going to be exceptional. It pays to settle the quiet title action, keep the homeowner in the home, and save the pooled interests, the pooled investors, $50,000 to $100,000 in legal fees. This reduction in principal and interest is not a loss. It's all that the new bank will get anyway, and the homeowner is generally judgment-proof so that the investors cannot recover any deficiency judgment. I hope that this clears up for you the meaning and value of a quiet title action. Don't buy any snake oil. Spend your money where you can get some value. Remember, there is no guarantee when you decide to use a quiet title action, but if you don't go that route, you probably will lose your property. Be wise and consider using a quiet title action to save your property. If you have any questions, please send me an email with a single word, question, in the subject part of the email, and include your name, state, and telephone number so I can give you a call and talk about your problems at no charge. Also, for homeowners and their lawyers, for a fee based on my hourly rate, I review complete files, including the whole file of any related court proceedings, and discuss the results of my analysis on what the next step should be to save the home from foreclosure and sale. To contact me, please call 212-307-4444.